Good evening, everyone, and welcome to the Brian Crombie Radio Hour on Saga 960. So I saw a blog written by a lawyer that I think very highly of, and an articling student, Erran Lee, who works with her, about LGBT rights in the workplace. And it was really quite fascinating. And so I reached out to the lawyer, and she said, you should meet and interview the articling student, because she's the brilliant one that wrote the blog. And so I want to introduce you to, if I could, Erran Lee, who is an articling student at Robbins Appleby, currently working within the litigation group. And she's written quite a very fascinating a blog article. And I don't even understand the whole title here. You're going to have to explain it. It's 2SLGBTQ and Human Rights in the Workplace. So maybe, Erran, before we get into you and your background, what the heck is 2SLGBTQ, please? Plus, I forgot the plus.
Yes, thank you, Brian. So 2SLGBTQ plus refers to a range of gender and sexual identities, including two-spirit, lesbian, gay, bisexual, transgender, and queer. And the plus sign actually stands for the inclusion of other gender and sexual minorities. So for any members of the audience who don't know, gender identity means a person's internal and individual experience of gender. And this can be different from someone's designated sex at birth, which often refers to the person's biology. And sexual orientation describes the way a person feels towards people of a particular gender.
What motivated you to write this blog?
Yes, so Barbara Green, who is a partner in our litigation group, as you were speaking about, reached out to me because she was interested in this topic. And I was very interested in this topic as well, as it's very important to me to be a good ally for the community. So I was very excited to be involved. Also at Robbins Appleby, our equality, diversion, and inclusion group is something that's very important to us. And that group has done great work at the firm. For example, in August, we had a seminar led by EGAL, who's a Canadian organization for 2S LGBTQ plus peoples and issues. And they did a workplace inclusion for gender and sexual diversity seminar, which I found very helpful and really helped our firm know what it takes to get to the next level of inclusion in the workplace. And I think initiatives such as this also shows that our firm does take inclusion and diversity to be very significant in a workplace.
Well, I found it really quite interesting. And so we're going to spend some time going through some of the findings and some of the conclusions that you've got in regards to the law. And also, I'd love to hear a little bit about what you think about what we need to do past the law, because it's not just the law, but it's the spirit of the law and the way that we include people that I think is key. But let's just talk about you for a second. So you're articling. How long have you been articling?
Yes, so I started articling in August, which means December will be my 5th month with the firm articling. So far, I'm in the litigation group, but our firm is rotational based. So in January, I will be switching rotations to the other groups, being tax and estates, corporate, and real estate. I've been really enjoying my articling term, as I did my summer last year during the 2020 summer with Robbins Appleby as a summer student. And that was before graduating law school from University of Toronto and writing my bar this past summer.
And what did you do before law school?
I did an undergraduate degree in kinesiology at
Kinesiology, really? Kinesiology to law? That's a little unusual, isn't it?
Yeah, it was a bit of a jump. But I got there and kind of realized the medical route wasn't really something that I was that interested in. And I'd always had law in the background of my mind as a potential career. And I sort of delved more into that and really enjoyed what I was learning and decided to go that route.
And the litigation specialty that you're in right now, is that just because of the rotation, or is that something that you chose to be involved in?
That is because of rotation, but I have really enjoyed being in litigation. I've really enjoyed the people that I work with here, and also the work is very interesting with a wide array of litigation opportunities that are here. And I've also gotten some very good responsibility on files as an articling student. So I've really enjoyed my experience so far.
And then you decided, or Barbara and you decided, to write this blog on oh my gosh, what's the definition again? S2, no, 2S LGBTQ plus human
Yes.
rights in the workplace. I got to ask you, and I apologize if I sound naive or uneducated. What's Two-Spirit?
Two-Spirit is something that's associated with Indigenous persons, and historically they would identify, certain Indigenous persons would identify as Two-Spirit, and in that culture, I'm not an expert on this by any means, but my understanding is in that culture they were very, these people were very much respected in the community and were doctors and healers, and they are, in some definitions of LGBTQ do not have the 2S out front, but they are a member of the community or members of the community, so it makes sense to include them in the definition.
And Two-Spirit would be both male and female, or different than that? What?
Yes.
Really? That's interesting. Okay, we're going to take a break for some messages and then come back more with Erran in just a minute, and hear more about this fascinating analysis she did and blog on diversity and inclusion and, laws in the marketplace in regards to this. Stay with us, everybody. Welcome back to the Brian Crombie Radio Hour on Saga 960. We're chatting tonight with Erran Lee. She is an articling student at Robbins Appleby, currently working within the litigation group. She's got a interesting background, the kinesiology background, then U of T Law School, and now she's been 5 months working with Robbins Appleby in the litigation group. And Barbara Sullivan, that's Barbara Sullivan, right?
Barbara Green.
Barbara Green,
Yes.
who's a litigation lawyer, came to her and asked her to write a blog on human rights for LGBT people. And she's written this blog on Two-Spirit LGBTQ plus human rights in the workplace. And we've just defined what Two-Spirit is, which is kind of interesting. LGBTQ, I think most people understand. And the plus, again, is for people that are even defined differently than that, correct?
Yes, it indicates the inclusion of other types of gender or sexual minorities.
So tell me, you've based this blog on Two-Spirit LGBTQ plus rights in the workplace. Can you describe for me what human rights exist regarding sexual orientation?
Yeah, so generally outside of the workplace, there are two different sets of rights based on provincial or federal. So the Ontario Human Rights Commission first recommended that the Ontario Human Rights Code be extended to protect individuals from discrimination on the basis of their sexual orientation in 1977, which was implemented in 1986. Then 10 years later, the Canadian Human Rights Act was amended to include sexual orientation as a protected ground.
So hold it. So it was recommended in 76 and implemented in 86?
77, it was recommended in Ontario and implemented in Ontario in 1986.
So it took 9 years.
Yes, it took a while. And then federally.
And then it took another 9 years or almost another decade for it to be done nationally.
Yes.
So things have happened slowly.
Yes, for sure.
Okay, sorry for interrupting. Go ahead.
No, that's okay. And being a protected ground means that persons are guaranteed the right to equality, equal opportunity, fair treatment, and an environment free from discrimination based on their sexual orientation. So they can't be discriminated against because they are gay, for example. And this applied to employment within the federal jurisdiction. However, the anti-discrimination or equality rights that are provided by our charter, which is in section 15, does not explicitly name sexual orientation or gender as a prohibited ground. Although there are analogous grounds, which are other characteristics other than those listed in the charter, which may also form the basis for discrimination.
Such as?
Sexual orientation or gender are now two of the analogous grounds. And that was actually decided in a Supreme Court of Canada decision in 1995 called Erran v. Canada. And in that case, a gay couple had lived together for almost 20 years, and one spouse applied for spousal allowance under the Old Age Security Act. However, his application was rejected on the basis that the relationship did not fall in the definition of spouse, which only included heterosexual couples. So the appellant brought an action seeking a declaration that the definition of spouse contravened the charter. And while the court held that the definition of spouse was constitutional, it held that sexual orientation was a deeply personal characteristic and classified it as an analogous ground, which means that since 1995, persons can base discrimination claims in the charter on their sexual orientation, which is a very big groundbreaking case for the community.
And so when was the Supreme Court case heard and found?
1995.
1995. And that's interesting. So what you're saying is that sexual orientation or this gay couple was analogous to something else that was in the charter. What was in the charter to start with that they were saying, while sexual orientation wasn't specifically in the charter, it was analogous to something in the charter. What was it analogous to?
It was analogous because they held that it was deeply personal characteristic, such that it was unchangeable or changeable only at an unacceptable personal costs, which was how they defined the other enumerated grounds. So that's why they held it was analogous.
Really? That's interesting. Okay. And so it sounds like this Supreme Court decision changed laws.
Yes. For sure, it changed the application of the charter for these for the 2SLGBTQ plus community greatly. It had a great impact on discrimination moving forward.
Really, that's interesting. So that's an example of where precedent is changing laws even before the government actually changes the laws, I guess.
Yes. And then a further Supreme Court of Canada case, Erran v. Alberta, held that sexual orientation must be read into human rights legislation around the country. For example, in that case, Alberta had not extended its human rights legislation to protect persons based on sexual orientation. And the Supreme Court found that the exclusion of sexual orientation from human rights protections infringed the charter. So it's decisions like this that have made a huge impact in human rights for the 2S LGBTQ community more generally, and that also seeps into the employment context.
So when was this Alberta decision?
Around 1998.
So 96 and 98, you had a federal Supreme Court decision, then a decision in Alberta in 98. And you think about all the different laws that would have human rights associated with it. What you're saying this Alberta court found is that every time human rights were included in laws, you had to include sexual orientation as one of those rights that human rights would apply to.
Yes, it was an Alberta case. However, that decision was handed down by the Supreme Court.
Okay, I apologize.
It applies federally.
Well. So this Alberta case, and so it's interesting. So did Alberta actually go to the Supreme Court and argue that sexual orientation was not a human right?
They argued that they should not have to include it in their human rights legislation, which was the Alberta Individual Rights Protection Act.
So I presume, like most people would have thought, human rights would have been gender and race and religion and things like that. And so I guess what you're saying is that Alberta must have argued that they agree that human rights would have been things like gender and religion and race, but not sexual orientation.
Yes.
That's interesting. That's fascinating. And they lost.
Yes, thankfully they lost.
And so those two cases changed laws in Canada?
Yes, for sure. They, because of the Erran case, the second case that we just discussed, now all provinces and territories have to include sexual orientation as protected under their human rights legislation, which is huge. It has a huge impact.
Did different provinces and or the federal government ever specifically legislate sexual orientation as a right, or was it only because of these precedents that occurred that sexual orientation is a human right?
Now, because of this case, the provinces all have to include in their legislation that it is protected.
So did they go back and like rewrite their legislation, or it's just because the precedent, that's how it's applied?
They would have had to gone back and rewrite their legislation, yes.
Really? That's fascinating.
Mm-hmm.
So some smart litigation lawyer took it to the Supreme Court and changed law.
Yes.
That's kind of exciting for someone like you, I can imagine, that you can change things ahead of what governments actually change. You can make laws more than politicians can make.
That's the goal, yes.
But that is kind of interesting, isn't it?
Yes.
We hear at least I don't know if about you, but I hear all the time about in the United States, Roe v. Wade as sort of this incredible precedent and how it changed U.S. law in the United States. What you're saying is these two laws changed laws in Canada and are as important in Canada as sort of Roe v. Wade was in the United States.
Yes, absolutely.
That's interesting. So tell me about how sexual orientation as a human right is currently protected, therefore, in the workplace.
Right. So as I said, in Ontario, sexual orientation is now protected by both federal and provincial legislation. So employees who work in federally regulated workplaces are protected under the Canadian Human Rights Act. And this act states that all individuals should have equal opportunity without being hindered because of their sexual orientation, which is a protected ground, and so is gender identity and gender expression. And there are several provisions relating specifically to the employment context, such as that it is discriminatory, indirectly or directly, to refuse to employ or continue to employ any person because of their sexual orientation or gender. And most people in Ontario are employed at provincially regulated workplaces, which means they fall under the scope of the Ontario Human Rights Code. And the code gives every person a right to equal treatment with respect to employment based on a number of protected grounds, which also includes sexual orientation, gender identity, and gender expression. And it protects every employee from harassment in their workplace by the employer, the employer's agent, or another employee because of these grounds. And it also states that every person has a right to equal treatment based on protected grounds with respect to vocational associations, including membership in a trade union or occupational associations, without discrimination based on these grounds. So we do have quite thorough legislation now, provincially and federally, which protects employees in the workplace from discrimination or harassment based on being a member of the 2SLGBTQ+ community. So we have come a long way from those Vreen and EGAN cases.
Okay, so that's really interesting, and you've run us through how the protection is provided. But how can their human rights for 2SLGBTQ+ people actually be impacted at work? Is it by things like, as you mentioned, pensions or healthcare not being supplied to a spouse, or would it be firing or hiring? What instances do you think are human rights impacted for this community?
Right. So generally, everything that you mentioned is a way that their rights could be impacted. However, there are many ways that the human rights of 2SLGBTQ+ community can be impacted at work. A few examples include, as you mentioned, benefits or policies assuming employees are in heterosexual relationships, perhaps offensive jokes or homophobic or transphobic slurs being used in the workplace, or even something like not having washrooms that are gender neutral can impact the rights of the community. Yes.
So in my office building, there's a men's washroom and a female's washroom. You're saying they got to put in a gender neutral washroom as well?
Yes. So to follow the best practices for persons in the LGBTQ+ community, it would be better and protect their human rights more to have a gender neutral washroom.
I was just wondering about the stick figures that showed a dress on one stick figure and pants on the other stick figure, and wondered, does that make females feel like they can't wear trousers to work?
Yes, I think that symbol is definitely assuming that each gender looks a certain way, which is definitely not a best practice for the 2SLGBTQ+ community.
That rolls off your tongue so well. I can't, I guess LGBTQ makes sense to me, but the 2S is interesting. But I like your two-spirit definition. Do you think these laws have changed society?
Yes, I think they definitely have. I think they allow individuals who identify with the community to feel safer at work and have more stability in their positions. It's also easier to come out now at work more than it has been in the past because of fear of being discriminated against or harassed or even terminated from their position if they were to come out. So I think these legislations and human rights have definitely increased the community's presence in the workforce.
You know, it's interesting. I interviewed a couple of weeks ago a female senior executive within the IT consulting business, and she said that the laws were helpful, but what was really critical is attitudes, because she said the most discrimination she got was things like Christmas parties and business dinners and things like that, where she didn't feel comfortable, or people didn't make her feel comfortable bringing her female lesbian partner, and that was the issue. And so that we needed to, yes, have the laws that you've talked about, but we needed to change attitudes, and that she felt comfortable, applying for all of the things that you talked about applying for, because human rights legislation, I guess, enforced her rights to have that. But still, within the business community, some people made her feel uncomfortable bringing her female partner, her lesbian female partner, to business events. And so she didn't. Right. So she ended up finding male friends that could attend those events with her. And she felt like she was sort of hiding herself and her true self at times.
Right. I'm very sorry to hear that. And I think it is definitely still an issue where many members of the community feel like they still must be closeted at work. Something that I know our firm has done, as I mentioned, was the EGAL workshop. And I think just bringing something like this to the forefront and encouraging all the members of the firm to attend, even someone like myself, I'm very accepting, and being a good ally is very important to me. I found the workshop to be enlightening and reminded me of some of the best practices. And I think something like that has the potential to change attitudes in a workplace and can make 2SLGBTQ plus individuals feel more welcome at work.
My kids are of your generation, and they say things have changed fairly dramatically. That in my generation, people might have felt differently, but that in your generation, people are colorblind and sexual orientation blind. That things are just, everyone's got friends of all different races, all different religions, and all different sexual orientations, and you're therefore far more comfortable and accepting and inclusive of that than my generation may have been in the past. Do you think that's true?
I do see us getting to be more inclusive. I hope so anyways, and I'm very happy to hear that your children passed along those messages. Even I think the laws, as we've talked about, say that sexual orientation cannot be discriminated against. And I think that laws do have an impact on social acceptance, because they say, at least legally, it's acceptable to be gay, or you have to be inclusive and not discriminate. So I think laws do have the potential and have changed social awareness and acceptance of these individuals.
Chatting tonight with Erran Lee. She's an articling student at Robbins Appleby, currently working in the litigation department, and she's written this blog with Barbara Green, a partner in the litigation department at Robbins Appleby, about 2SLGBTQ plus human rights in the workplace. And we're having a discussion about that. We're going to take a break for some messages and come back more with Erran in just a minute. Stay with us. Welcome back to the Brian Crombie Radio Hour on Saga 960. I saw this blog article being publicized by a lawyer, Barbara Green, that I know from Robbins Appleby, and she was bragging about the articling student that wrote it, and it really was quite interesting. And so I read it and asked Barbara if she could come on my show to talk about it, and she said, "No, you should get Erran Lee, the articling student, to come on." And it's about Two-Spirit LGBTQ plus human rights in the workplace, and it's written by Barbara Green and Erran Lee. And Erran, you spell your name Erran. That's the strangest spelling of Erran I've ever seen. Is it like Irish or Scottish or something or other? What's the background of Erran spelled Erran?
The background is that my parents like the name Erran, but they did not like the spellings that were available. So they came up with their own spelling. And that's where I got Erran.
Do people spell it wrong all the time?
They spell it wrong and they say it wrong based on the spelling. So I
What do
often
they,
thank them
Iran?
for that unusual spelling.
What do they pronounce it as?
Erran.
Iran. Oh,
Yes.
okay, that makes sense. We've talked about the law, and it's been really interesting to me because I didn't realize these two Supreme Court cases that you talked about were so impactful in changing human rights legislation in regards to sexual orientation in the past. But I wonder if you could tell me a little bit about what constitutes discrimination and harassment in the workplace as it would apply to sexual orientation.
Right, thank you. So discrimination and harassment are obviously considered two different things. Discrimination is undefined in the Ontario Code, but according to the Ontario Human Rights Commission, discrimination because of sexual orientation includes any distinction, including exclusion, restriction, or preference based on sexual orientation that results in the impairment of the recognition of human rights and fundamental freedoms. This is to be contrasted from harassment, and harassment is because of sexual orientation is not explicitly included in the code. However, in Crombie versus Asselstein, which was an Ontario Human Rights Tribunal, it addressed harassment relating to sexual orientation and relied on a Supreme Court of Canada decision, Jansen v. Platy Enterprises, which held that sexual orientation was a form of sexual discrimination and that sexual harassment was a breach of one jurisdiction's human rights legislation prohibition on sexual discrimination. So Crozier, relying on that decision, held that harassment because of sexual orientation was a form of discrimination based on sexual harassment. So it's decisions like this which have taken another jurisdiction's application and given us more range to look for when trying to bring a claim in harassment based on sexual orientation. And harassment is defined in the code as engaging in a course of vexatious conduct or comment that is known or ought reasonably to be known to be unwelcome. So it has both a subjective and objective test, which means it looks to the harasser's knowledge of how their behavior is received, as well as the point of view of a reasonable person, which includes the person who has been harassed.
What's vexation?
Vexatious?
Yeah, that's an interesting word.
I believe it means vexatious comment or conduct. Like mean, rude, something that would be known to be unwelcome to the person who's experiencing it.
That's an interesting word. I'm going to have to use that in a sentence. I like that. So if you think you've been harassed or discriminated against and your human rights have been negatively impacted, what's your recourse? What do you do?
Right, so there's a few options for bringing a claim in Ontario. So if you're an employee, you could launch a civil action in court for wrongful dismissal if you feel that you've been dismissed because of your sexual orientation, and you could tack on a human rights complaint. You could also file a complaint with the Human Rights Tribunal of Ontario if you're being harassed in the workplace. However, there are no costs awarded at the commission, which may be a good thing because in Ontario civil courts, often the so-called loser is often ordered to pay some of the victor's court costs. There has also been an increase in the quantum of damages that are awarded to damages for employers who have acted poorly and harassed or allowed harassment in the workplace. The benefits of going to the tribunal include that it should be easier and cheaper for the public to access. Unfortunately, there are limits of the types of damage that you can receive. And COVID has also affected the tribunal's efficiency because they effectively stopped processing complaints for more than a year. So there is a bit of a backup now.
They stopped completely?
Yes, essentially, yeah. They shut down for about a year because of the pandemic. Maybe heard a couple of cases, but definitely not at the same rate that it was pre-pandemic.
So there's a right to be tried within a certain time period. If employers or workplaces or someone in that workplace was harassing or doing something discriminatory, have they got sort of a free pass because of the lack of hearings for a year?
No, so I believe the right to be heard in a reasonable time applies more to criminal jurisdiction. I'm not a criminal expert by any means. However, there is definitely still room to bring your claim if you are someone who has experienced harassment, even before COVID or now. It definitely hasn't been statute barred or anything yet.
I understand you were going to give us an example of someone that was harassed or discriminated against and what happened, or a case study. Tell us about it.
Yeah. I'm just trying to get my share screen up. I'll just share screen for slideshow for anyone who can see it.
And this is going to be an example of someone that was what, harassed or discriminated against, or what?
Yes, so this is a case study based on transgender. Can you see my slideshow? Oh, no.
Yep.
You can, okay. So this is a case study based on transgender rights in the workplace. So it's important to take a look at cases to see down on the ground, the practical reality of what happens or what can happen if you have had harassment at work because of a protected ground.
Okay.
So this case was a 2012 Human Rights Tribunal case, and it shows the potential consequences for an employer who do not ensure the human rights of their employees are respected. So as I said, this case specifically concerns the right of a transgender employee. Okay, so when the applicant, who was an employee, began working with the employer, she lived her life as a man, but transitioned to living as a woman as she worked there. She began sex reassignment and hormone treatments during this time. The respondents included the employer, who was a paper product factory, and an individual respondent who was the appellant's former colleague. The applicant brought a human rights complaint alleging harassment, a poisoned work environment, and that her dismissal violated the Human Rights Code. And regarding the individual respondent, the applicant alleged that he played a central role in her harassment. And of course, these allegations were denied by the respondents. So the applicant had several incidences constituting evidence of harassment. For example, the plant manager had told the applicant that she could not use the women's washroom until she was able to prove she was female, even though she identified as one. The applicant was also facing comments and harassment from male employees while changing, and requested a modified shift time so she could change alone in the change room. However, the plant manager denied the applicant's requests. There were also many harassing comments to her about her gender identity while she was at work. One major issue in the case was the applicant's dismissal. So she was dismissed following an altercation with the individual respondent, whereby she alleged that he yelled a comment about her, calling her derogatory terms and cursing at her, and she threw a skid at him. So the applicant was dismissed, and the employer said that they had given her many chances to improve her behavior, which she had not done, so she was being terminated. Her employment was being terminated. So when it came to the Human Rights Tribunal, the adjudicator accepted that the applicant was regularly subject to name calling, that the individual respondent used derogatory language towards her in the incident that led to her dismissal. As well, the adjudicator found that the applicant was subject to a poisoned work environment through the harassing comments and by being forced to use the men's change room. The adjudicator held that the employer contributed to the poisoned work environment by insisting that the applicant use the men's change room, their own statement and action, including not permitting her to use a woman's washroom, and by failing to investigate and respond reasonably to the applicant's allegations. The adjudicator concluded that the applicant was harassed in the workplace and the employer contravened the code by creating a poisoned work environment. The dismissal was also contrary to the code, as the applicant's gender identity factored into her dismissal. And as we learned previously through our discussions, you're not allowed to base a dismissal on someone's sexual orientation. So this is what impacted the claim here.
But what about throwing the skid?
Because of the way that the work environment had been poisoned by the harassment and discrimination by both employees and the employer, the court still found that there was a human rights complaint here, and the skid throwing was taken into consideration in the damages award. So the applicant was awarded $22,000 in general damages for her injury to dignity, feelings, and self-respect, of which the individual respondent was only required to pay a small amount. However, it is important to note that the adjudicator did consider the applicant's own behavior, including previous insubordination or aggressiveness, which would include the skid, such that there would have been a greater damages award if her own behavior had not crossed the line in these instances. The adjudicator also awarded the applicant 8 months lost wages and required the employer to retain a human rights expert to assist in developing and implementing a human rights and anti-harassment policy, as well as provide training to the managers. And it's damages like this that can really make an impact in the workplace. And I think they're more towards attitude changing rather than reprimanding for the one instance of harassment and discrimination.
Well, that's really, really interesting.
Yes, certainly.
Some takeaways for us.
Yes. So this case reminds employers of their obligations to protect human rights in the workplace. It shows that employers' obligations include accommodations to employees that may be experiencing harassment, as well as investigating allegations of harassment and responding reasonably to the complaints, which is something that the employer in this case did not do. It also reminds us that sex or gender identity cannot be a factor in an employee's dismissal, as it was here. And the employer cannot insist that someone be treated as a man if they identify as a woman. Insisting on someone identifying their gender with their biological sex is not correct. And based on our human rights code, employers are not able to do that. And generally, this case shows that there are a wide range of harassment and discrimination methods that can occur at work that can impact the human rights of people who identify with the 2SLGBTQ+ community.
So, I find that interesting, but, in your last one, what if some of the females didn't feel comfortable having this now identifying as a female person that yet hadn't completed the gender transition coming into their washroom? What if they complained that they didn't feel comfortable? Would that still be harassment?
If the employer was insisting on the employee not using the female's washroom, even though they identify as female, that would still constitute harassment. I don't have any particular case law that says that, but I presume it would still be harassment because it is forcing someone to identify as a gender against how they themselves.
I'm not talking about the employer forcing her to use the female washroom. I'm talking about females that complain that, this person's not a female yet, they're still transitioning, and we don't feel comfortable having this individual that used to be a man now transitioning to being a female using the female washroom. What if that happened? Would that be harassment or discrimination?
Right. If the employer,
not the employer, the employee.
You're talking about other employees harassing?
With the female employees, if they objected to having this individual that used to be a man that's now transitioning to be a female but isn't complete through that transitioning process. So you said that they hadn't had the sex change operation yet, but they were taking hormones or something like that, I think was what your fact base was. Right. Would they be guilty of discrimination?
It depends on how they went about voicing their concerns. If they were using derogatory terms or verbally harassing the other employee, then that could be harassment. If they raise their concerns in a reasonable manner, then I can't foresee that being harassment.
It's interesting because, we've heard stories about the Olympics disallowing some females from competing as females because they've got too high testosterone, or because their genitals may be slightly sort of normal. And they weren't charged with discrimination, though people may have thought it was completely inappropriate.
Right. Yes, I think those cases are very new in the sports context, and it'll be interesting to see where the law takes them in the future.
We're chatting with Erran Lee, who is a articling student at Robbins Appleby, has written a really fascinating article on discrimination in the workforce because of workplace, because of sexual orientation. We're going to take a break, a final break, and come back with some concluding comments in just a minute. Stay with us, everybody. Well, I've had fun tonight talking to Erran Lee, who's an articling student at Robbins Appleby, currently articling in the litigation department. She's got a law degree from the U of T Law School. She's got a kinesiology undergrad from New York, which sounds kind of interesting. And so probably you know more about the sports cases than I thought you might because of your kinesiology background. Erran, it's a fascinating article that you've written. Thank you so much for sharing that with us. What do you think the takeaways are?
Right. So I think that there are takeaways for every employee and employer out there. Employees who identify with the 2SLGBTQ+ community should be aware of their human rights in the workplace specifically, and how they can be impacted and which steps they can take if those rights have been infringed. However, there is something for everyone to learn, not just those who identify with the community. A great message that listeners can take away is how to help create a more positive environment for members of the 2SLGBTQ+ community in the workplace and help ensure that their human rights are respected. Specifically employers, there are a number of steps that employers can take to make sure that their workplaces are more 2SLGBTQ+ friendly. For example, as I've stated, Robbins Appleby brought in a speaker from Miguel to do a seminar, and I think that was a really positive step towards advancing equality and inclusion in our workplace. Other things that employers could implement to make the community feel more welcome include ensuring any uniforms are gender neutral, encouraging without mandating the use of pronouns in signature lines in emails and other correspondence, as well as providing gender neutral washrooms, which we touched on several times, creating an inclusion committee, such as the one we have here at Robbins Appleby, and ensuring that workplace policies do not assume heterosexual relationships. Although it is easier for employers or persons in supervisory roles to create these changes, every individual can help make an effort to ensure that there is an inclusive workplace for the 2SLGBTQ community. And employers who do have ideas on how the workplace can be more friendly towards these individuals should speak with their employer about their ideas.
Erran Lee, articling student at Robbins Appleby. Thank you not only for the education in regards to the Supreme Court findings and what defines discrimination and harassment, but I thought your final little blog, your final little rant, your final little conclusion, takeaways was really helpful. And let me add to that by saying I think this is something really critically important, and it comes back to that line that lots of people have talked about, in that diversity is a fact, inclusion is a choice. And a lot of people now saying that diversity and inclusion hasn't gone far enough. We've got to come to equality. And I think really this world is one where there are so many different people, whether it be race, religion, gender, or sexual orientation. And we just got to become a lot more inclusive, a lot more accepting, and treat everyone equally. And I think that you've done a service in that regard by showing us where the law is. But you've also done a service by giving us the takeaways of how people have got to treat everyone else with respect. So Erran Lee, thank you so much, and good luck with your articling and your and you're becoming a lawyer. I look forward to you arguing something in front of the Supreme Court, because I think you're going to do a great job. Thanks so much.
Thank you. And thank you for having me on, Brian.
That's our show for tonight. Thanks for joining us. I'm on every Monday through Friday at 6 o'clock on 960 AM. You can stream me online at www.saga960am.ca. Good night, everybody.